took some items from the store that were unpaid for.
Okay, and you tried to walk out with them?
Correct.
Those case, People versus Kenneth Hall, minor cases, as well as the cases that are currently felony cases with charge. So in case ending in 997, the court's defendant pleading guilty to the charge of retail fraud, second degree. That is also the case in the case ending in 58 or 0585.
The case ending in 585 shall be pleading to an added count 2 of retail fraud third.
Really?
Yes. We'll be dismissing count 1.
Okay, hang on. To be pleading dismissing count 1 on that. Okay. Just want to make, but on the case ending in 997, is she pleading to retail fraud second?
That is correct.
Okay, so she's pleading straight up in that. In the case ending in 676, I believe we have
Dismissal.
that case is going to be dismissed.
Outright, yes.
Wow. You're down to 7.
The same is true for the case ending in 744.
You're going to dismiss that one.
Correct.
Okay.
The 4 cases you have listed already, I do want to note that there is no restitution at issue in any of them as well.
Got it. Okay. So those are resolved the misdemeanor cases that Ms. Constantino made us bring in. Then on the case ending in 0192, defendant's going to be pleading guilty to the charge of retail fraud second degree, with count 1, the retail fraud first degree, being dismissed.
That's correct.
In case ending in 0556, he's going to, do we have a plea form on this one? No, what she's going to be pleading to the stated count 2, count 1 would be dismissed.
That's correct.
In the case ending in 0428, she will be pleading to an added count 2 of larceny by false pretenses, the 1-year offense, and the uttering and publishing will be dismissed. There is an agreement of restitution. Is this Childers writing?
No.
Okay. $1,120.88.
Yep.
Oh. Yep, I could still read chicken scratch. All right. And in the other matter ending in 1138, she's going to plead guilty to, is there a stated count 4? Added count 4 of use of a controlled substance, that being cocaine, to 1-year offense. And counts 1, 2, and 3 in that case would be dismissed.
Yes, Judge. And we, there is an
No
understanding.
objection to 7411.
Yes, thank you.
Bernard, you have one little cherry on top.
It's great.
Just so that we don't have to come back here. There is a warrant waiting in the queue with an offense date of July 2023 associated with Pittsfield incident number 2310401. Because we are resolving all of these today, we are not going to authorize that. We're going to deny that. There is no restitution at issue in that case.
Okay, I'll take that. Yoder, you need to do everything you're going to do on one day.
I am.
All right.
Yeah, I'm done. Yeah.
Okay, all right, well. You can help it, but what the heck? May we have her sworn, please?
Right. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Jessica Yoder.
All right. You've heard the agreement in terms of your pleas.
Yes.
All right. So to the charge of use of a controlled substance, cocaine, contained in case ending 1138, how do you plead?
Guilty.
All right, and I should indicate that's a misdemeanor punishable by up to 1 year $2,000 fine plus court costs. You understand that?
I do.
All right. To the charge of larceny by false pretenses contained in case 0428 that is punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if the value of the property is greater than $2,000, 3 times the value of the property. That would become the maximum fine. You understand that?
Yes.
How do you plead to that charge?
Guilty.
To the charge of non-sufficient funds less than $100, that being a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. That's contained in the case ending in 0556. How do you plead?
Guilty.
To the charge of retail fraud, second degree, that being a misdemeanor, punishable by up to 1 year, a $2,000 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine as contained in the case ending in 0192. How do you plead?
Guilty.
To that same charge of retail fraud, second degree, punishable as I have indicated, contained in case 0997. How do you plead?
Guilty.
To the charge of retail fraud, third degree, as contained in the case ending in 0585, which is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and where the fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yeah, I do.
You signed advice of rights forms. Is that correct?
I did.
Any questions you had regarding any of those rights?
I do not.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No, Your Honor.
Anybody threaten you or coerce you?
No,
You're doing this voluntarily
I am.
and of your own free will.
I am.
And as to each of these charges, because you believe that you're indeed guilty of them?
Correct.
All right. Starting in case, so I'm going to go backwards from where I was going. Starting in the case ending in 0585. It's going to be back here. On the date of March 18, 2023, at the location of 7,000 East Michigan Avenue, that being the Walmart, Pittsfield Township, Washtenaw County, State of Michigan, what did you do on that date that makes you think that you're guilty of this offense?
I took some items from the store that were unpaid for.
Okay, and you tried to walk out with them?
Correct.
All right. And we did this. And the total of the items that you tried to remove from the store, was it greater than $200? Well, you just took some items from the store. You didn't, this was the one that was reduced. You didn't have anybody's permission to take that property, did you?
No.
This property that you took was offered for sale by Walmart?
Yes, it was.
All right. And the store was open to the public?
Yes, it was.
Going to case ending in 0997. That's a retail fraud second degree, also charged. On the date of April 30th, 2023, at the location of the Meyer store, I think it's 38. I don't know which Meyer you went to. At the location of 3145 Ann Arbor Saline Road, Pittsfield Township, Washtenaw County, State of Michigan, that being the Meyer store. What'd you do on that date that makes you think that you're guilty?
I took items that were for purchase from the store without consent.
And without paying for them?
And without paying for them.
All right. And the aggregate amount of what you took on that date, was that greater than $200?
Yes.
All right. And the store was open to the public at the time?
Yes, it was.
Of course it was. It's Myers. All right. Going to 0192. That being also a retail fraud second degree. That's good information. So on the date of August 30th, 2023, location of 3749 Carpenter Road, you're just all over. That means Target store. Okay? What'd you do on that date that makes you think that you're guilty?
Judge, may I have voir dire?
Sure.
Ms. Yoder, on that date, were you at the Target store on Carpenter Road?
Yes,
And you took some items from that Target without paying for those items, correct?
yes,
And you didn't have consent or permission to do so, correct?
correct.
And you walked past all points of checkout that day, correct?
Yes.
Without paying for the items,
Yes,
correct? And the value of those items were valued at over $200, correct?
yes,
And the store was open to the public at the time?
yes.
All right. Okay, so let's see pertaining to in this one. Okay, this is at least something different.
Gotta spice it up
The
every once in a
case
while.
ending in 0556 on the date of December 20th, 2020, at the location of 771 Airport Boulevard, that being the Costco. What'd you do on that date that makes you think that you're guilty of the non-sufficient fund check less than 100?
Your Honor, may I voir dire?
Please.
Ms. Yoder, on that date, you presented a check to a Costco location, correct?
Yes,
And that check, you presented that check knowing that it did not have sufficient funds to clear or be paid for, correct?
yes,
And
And those,
go ahead.
and that those funds were valued at about $60, correct?
yes,
All right. And when given the opportunity, there were never sufficient funds to cover the check. Is that correct?
yes.
All right. All right, going to the larceny by false pretenses contained in case 0428. And where's my complaint? There it is. On June 16, 2023, at the location of 6950 Jackson Road, Scioto Township, Washtenaw County, State of Michigan. What'd you do on that day that makes you think that you're guilty of the larceny by false pretenses?
I cashed a check that came back as counterfeit for $1,120.88.
You cashed it? What do you mean you cashed it? You took it to the bank?
I what?
What do you mean you cashed it?
I took a check that was written to me to Scio Foods and they paid me for it.
Okay, and you knew that the check was counterfeit? Or,
Yeah,
Well,
you're gonna need more than that. Ms. Yoder, how'd you come into possession of the check?
it got mailed to me,
The check got mailed to you.
correct?
Did you have reason to anticipate that this check would come to you?
We had a few people in our family pass away, so there was a few different checks coming in to me and my husband for different things. And I thought that it was for one of them, but it apparently wasn't.
Okay, Ms. Yoder, you've done a lot of stuff, so, right? When you took that check to a bank? Is that what you did?
No, I took it to a store,
A
party.
cash? kind
because
of-
I don't have a bank account.
Gotcha. Okay. And when you took it there to cash it, did you know that it wasn't for you or was that?
At the time, I didn't know it wasn't gonna clear.
Okay, we're gonna have a problem with that one. Well, you didn't know. Was the check made out to you?
It was.
So again, Ms. Yoder, so when you got there, did you think? So when you got there, so when you you took the check to the store, right? When you walked in the store to cash the check, did you know that it wasn't a good check and wasn't supposed to be for you?
No,
All right. Even shortly thereafter, like right after you did it, did you know?
he contacted me once after that. Yep, and then I never went in after that.
Who contacted you?
The owner of the store.
Judge, may I ask
Yeah,
Is it my
'cause
case? I should not speak.
Yeah, go ahead. I mean, I don't know whose case it is, but.
So you got.
Yep.
All right, if I may,
Go ahead.
Mr. Yoder, when you cashed the check, you got items for the check.
Yes,
Okay. Then you were notified that the check was not cleared.
correct.
You kept the items
Yes,
and you did not pay the check back.
correct.
And that value was under $200 the items. It was over $200.
But okay, I don't really mean to be the fly in the ointment here, but I will be. At what point is there, or is anybody thinking that there's some false pretense on her part?
At the time,
May I walk here? I'll get.
Okay.
Mr.
Did-
Yoder, have you ever worked for a business called Anderson Process?
No,
Is there any reason in the entire world the business of Anderson Process would be paying you money?
no,
So when you cash a check that was drawn and written by Anderson Process and made out to you, is there any reasonable reason why you would ever thought you'd be deserving of the money on that check?
no,
And you cashed it anyway?
yes,
And when the bank called you and said or when the store called you and said that money, that check was bad, did you make any efforts to rectify that situation?
no.
Okay. I'm a little bit sufficiently lost at this point. So did that check come to you in the mail?
Yes,
From who?
I don't know.
Okay, so let me just see if I get this right. This check comes in. You said you had family members pass away
Yes,
and there was money coming in.
yes,
This check is coming in from a business addressed to you,
correct,
right? Or made out to you.
correct,
You knew you had not worked for them.
correct,
You knew of no reason why they would be paying you money.
correct.
But you went into, that's the business you went into?
Yeah.
You went into that business and cashed the check.
Yes,
But hold on, did you take the check? So Anderson, whatever, wrote the check out, or it appeared that they wrote the check to you.
correct.
You took it to the maker of that check. You didn't take it to the bank, right? You took the check to the maker. Would you be Anderson? Or did you?
No,
No.
she took it to a store.
I took it to a store.
You took, okay,
And-
so
and got
someplace
items in
other
exchange.
than Anderson.
Yeah.
Okay, that's where I was getting mixed up with my story. So you took it someplace else, knowing you had no reason to receive the funds that were represented by that check.
Yes,
And you cashed it.
yes,
And then when they called you, whoever the bank or whoever called you, you didn't make good on that check or return the funds or the items that you got for that check.
correct.
Okay. I'm gonna ask you this question again, just so that we have a clean plate.
Okay.
You knew when you went into that store that the funds that were represented by that check, that you were not entitled to them.
Yes,
Okay. It couldn't be easy with you, Wielder. All right, this one may be a little bit easier. let's see. On the date of, it's all cut off on that copy, beautiful. Undated June 7th, 2021. Location of 2126 Ecorse Road, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in possession of cocaine?
Yes,
Had you used it?
yes,
Did you know what you were using was cocaine?
yes.
Yay. Black decision. I'm saying yay because the plea went. Okay. Counsel, as to all of those cases, has the court complied with the court rule, and would it be proper to accept this defendant's pleas of guilty to the respective charges?
People are satisfied.
The defense on behalf of Ms. Yoder in my cases is satisfied.
Yes, we're satisfied. Court will accept the defendant's plea of guilty to use of cocaine. Court will also accept the defendant's plea of guilty to larceny by false pretenses contained in 428. Will also accept the defendant's plea of guilty to the charge of non-sufficient fund check less than $100 representing case 556. Or will also accept the defendant's plea of guilty to the charge of retail fraud second degree contained in case ending in 0192. Or will accept the defendant's plea of guilty to the charge of retail fraud second contained in the case ending in 0997. And will also accept the plea of guilty to retail fraud third contained in the case ending in 0585. Defendant, in all of those matters, I will keep all of these cases. The defendant is referred to probation 14A1 District Court for pre-sentence investigation and court. Sentencing in these matters will be
April 24th at 1 p.m.
that soon. Oh, man, she's got to come
Oh,
back. No, that's fine.
We'd appreciate that date.
I'm not doing anything nice for Constantino ever again. April 24th, 2024, 9 a.m.
And Judge, I apologize, but there is an issue of
Oh, you got something?
Bond.
What?
bond.
Which case?
Of bond.
Which
Okay.
case? Do
Judge,
we know?
it's actually all of her cases. Her current bonds in all of these cases are currently personal bonds with release to treatment. However, because she has a hold out of Wayne County with release to treatment and a tether, she's not currently being released from Washtenaw County Jail into treatment because she would have to first go to Wayne County, get the GPS tether placed, and then go to treatment. So it's my understanding the intent of the bonds was so that she would be able to go to treatment, but currently the bonds are not allowing her to go directly to treatment because she first has to go to Wayne County to get the tether placed. So what we're asking the court to consider doing is issuing personal bonds on all files and without the release to treatment condition, because then she would automatically still go to Wayne County, have the tether placed, and be released to treatment. Currently, the way it's worded, the jail will not release her to treatment.
Got it.
But if they are all just personal
No,
bonds.
I got you. I got you. People have any thoughts regarding that?
My only thought would be if we do that, that 424 date is not going, because it may take some time for the go to Wayne County, see, all of those things to happen, be released, make her PSI appointment, so on and so forth. So I don't have an issue with that sentencing.
Well, okay, so here's the thing. We're really looking to get her to treatment, right?
Yes.
So if I release her on a PR, she's gonna get, well, she'll get to Wayne, get released on the tether. Our ultimate objective in terms of getting her into treatment won't be happening.
Well, it would, Judge, because her bond conditions in Wayne County are a GPS tether and she must be released to treatment. So Wayne County is also ordering release to treatment.
Okay, but okay, so what happens in Wayne County if there is no treatment available? Because that's what the problem is here. So what would end up happening then is that she's then held.
It's not that it's not available here. It's because of my Wayne County hold that I can't go.
No, well, treatment, we got issues.
Okay.
Yeah, I'm talking about something else. I'm just worried about her getting held in Wayne and then not getting back here because they're waiting for available treatment for her. So here's what I'm gonna suggest. We're 13 days out from sentencing. All right. Let Ms. Polera get to you. Get that recommendation in place. I mean, if I have to move up to date, I'll move up to date. But then but the object from my standpoint would be to get you sentenced to treatment, okay? And then we can do the PR, we can get you on your way to deal with Wayne County, get back here so that we can get you into treatment. That way, at least in Wayne County, you have something to say if they won't release you to treatment, that Washtenaw has ordered you into treatment here. Does that make sense? It may not make sense,
It
but
doesn't, because I feel like I'm still in the same spot.
I know.
If I'm ordered to treatment through both places, I am ordered to treatment through both places right now.
I know. But what I want to have happen is I want to be able to sentence you to the treatment prior to letting you go there where it's sort of a pretrial condition.
So then I have to go to Wayne County and then back here.
No.
Well, you'll have to come back because you'll have to report to probation. What I want to do is I want Wayne County to release you back here so we can get you into treatment.
So yeah, so that means I have to,
So Judge, would that be after that? And that would be after her sentencing on the 24th.
Correct.
then I have to go to Wayne. County.
And what, Ms. Yoder, what I will try to do, okay? I don't know why you're in such a rush. It took you forever to get all these cases. I'm sorry, that was
Because I've been.
that was rather flippant. No, I'm just saying this. If Ms. Polera can get to you and Ms. Polera can get these reports done and everything, and we can get counsel either on Zoom or whatever and get you up here where I can sentence you earlier than the 24th and 12 days from now, I'll do it. Okay? Because you've been lingering here for a while. And so I want to get you moving in a certain direction, okay?
Once I go to Wayne, I have to sit there until I'm done with them and have to come back here. I'm not even gonna be able to go to treatment.
In where?
In
In
Wayne
Wayne?
County, I'm not even gonna be able to.
No. That's not what I'm saying. What I'm saying is here, I want to get you into treatment. That's my ultimate objective. If it's here, if it's through Wayne County, or if it's through here, it doesn't really matter to me much. I want to get you sentenced here. We will be ordering as part of your sentence treatment, right? But then it doesn't really have a date per se. You'll get PRs then on these. You'll go to Wayne. If you get into treatment there, you satisfied my condition on all of these cases. I'm just trying to have some orderly way for it to happen. I'm not attempting to try to send you there and then send you back. If you get there and they hold you, we'll at least know. But in the end, once they put you to treatment, then you satisfied these 6 cases.
Yeah, because they were releasing me to treatment in the first place, and that's why I came here.
Correct. I don't want that. Right now, if I do that, that's why it can't happen the way that it's happening. All right? Do me a favor. Just trust me a little bit on this. It may not work, but it'll be my best effort to do it. Okay? All right? You trust me? Whew. If you had said no, we would have had a long road. All right. All right. That's the way we'll do it. And we'll see if we can get to Miss Polera, see if we can get to you. And if I can get you in sooner, I will. All right. All right.
Thank you, Judge.
Thank you.
And thank you for the accommodations today. We appreciate you
This
handling all the
wasn't an
cases.
accommodation. This was a war.
Thank you. We appreciate you.
Case people versus Mark Essenberg.
Bernstein for Mr. Essenberg, Your Honor, coming up to the podium. Asking for a slightly lengthier adjournment than the last ones, Your Honor. He's in discovery group. He's going to AA. We're doing a full-scale treatment to work towards a resolution.
All right. Probable cause conference, May 9th. Will that,
Please, Your Honor, that'd be perfect.
May 9th, 2024. 9 a.m. as your invite indicates without objection, bond continued.
Thank you, Your Honor.
Thank you.
Great day to you and your staff.
You too. Court calls the case People versus Ethan, is it Romack?
Sinatra, Senior Assistant Prosecuting Attorney.
Your Honor, Troy Gorman, appearing on behalf of the defendant.
Ethan Romack.
Your Honor, this is the date and time for the probable cause conference. Hopefully, we'll be having further discussions with the prosecution, but it appears that we're ready to move forward to the preliminary exam.
All right, is all discovery complete?
I don't believe it is.
Well, and why are we moving ahead? You don't have all of the discovery?
I don't know what there is, Your Honor, so I don't know.
Do you have like the police report?
I do not have the police report.
Okay, then I'm not setting it until you get the discovery and can look it over and talk to your client about it. So, do you know how to request it here?
I do, Your Honor.
Okay, so I'll adjourn out the PCC for you to be able to get that and talk to your client, see what you guys really want to do on this, okay?
Thank you, Your Honor.
Well, probable cause conference, I'll adjourn it to May 2nd, 2024, 9 a.m. or as your invite indicates, bond will continue. Court calls the case of People versus Dante King.
Peter Childers appearing on behalf of the people.
Good afternoon, Your Honor. Sarah Kraus. I'm standing in for record copy Silver for Mr. Dante King, who is also present on Zoom.
All right, your name, sir?
It's Dante King.
Thank you. What are we doing on this today?
Judge, we are asking for a adjourned probable cause conference. I did email Mr. Childers. We are missing some discovery in this matter.
All right. Why don't we go May 2nd? Will that work, counsel?
It will, Judge, and I'm also asking permission to appear by Zoom at that time. Mr. King is not a resident of this state.
What state is he in?
Ohio.
Ohio?
Yes.
That's really Michigan, like misplaced.
I would disagree,
anyway.
Judge, but Michigan is much better.
I know, but part of it really is ours. We gave it to Ohio. We got the UP, whatever. May 2nd, 2024. And yes, you can appear via Zoom, 9 a.m. or as your invite indicates. Bond
Thank you.
continued. Thank you.
Thank you.
Does call the case of the People versus, is it Kanasia Johnson Jackson?
Assistant Prosecuting Attorney working on behalf of people.
That's a lot.
Good afternoon, Judge Simpson. Robert Mullen on behalf of the defendant, Ms. Jackson Johnson.
And good morning, Your Honor. Miles Drew, also on behalf of Ms. Johnson Jackson, P number 84554.
Why don't you set it first? Ma'am, what's your name?
Kenyasia Johnson Jackson.
All right.
Oh, Prosecutor, Your Honor, I believe we're going to need a little more time, only because we just were tendered some discovery yesterday that's still downloading, and it's quite voluminous. And I know that you like to make sure that we have all our discovery, as well as we've reviewed it prior to an actual preliminary exam. I do see the case going to preliminary exam, but we might need a little bit.
How much more time did you need?
At least a few weeks, and maybe a month. Only reason I say that, Judge, is I'm starting 2 trials in the next 2 weeks that I know are going for sure. I mean, there are a couple of years.
May 9th.
Would this be for the actual preliminary exam, Your Honor?
No, it'd be for probable cause.
Yes, Your Honor.
May 9th. Without objection, 2024, 9 a.m. or as your invite indicates, bond in this matter will continue.
And Your Honor, I think for the record, we need to have to waive the 21-day rule. I know that it's our request to go outside of it. There is good cause, but I think it would be better if I could vaude to her briefly. Ms. Johnson Jackson, you realize you have a right to have a preliminary exam within 21 days of your arraignment.
Yes,
I've discussed that right with you.
yes.
I'm asking you to waive your right to have the hearing within 21 days to give us time to review the discovery and be prepared for the preliminary exam.
I'll waive the right.
Thank you, Your Honor.
Thank you.
Have a good afternoon, Judge.
Court calls the case People versus Terrence Powell.
Kenneth Overwater, Assistant Public Defender. On behalf of Mr. Powell, who stands to my right. Mr. Powell, would you state your name for the record, please?
Terrence Powell. Thank you.
This is Ms. Hughes' case. I had asked for an offer. She was going to speak with the OIC. I'm guessing that hasn't happened yet this morning. So I just asked to adjourn the probable cause conference.
Probable cause conference will be adjourned April 25th, 2024, 9 a.m. or as your invite indicates, bond will continue. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Court calls the case People versus Courtney Smith.
Andrew Childers appearing on behalf.
Courtney Kathleen Smith.
Thank you.
I've spoken to my client and to Mr. Childers, and we are requesting a preliminary examination, please, Judge.
Discovery complete.
That's my understanding, yes, Judge.
People have their witnesses available the 23rd. Preliminary examination will be set April 23rd, 2024. 9 a.m. in person before Judge Washington.
Okay.
All right. Bond continues. Thank you.
Have a good day, Your Honor.
You do the same. Court calls the case People versus Levi Johnson.
Your Honor, Joe Simon on behalf of Mr. Johnson. Mr. Johnson should be, there he is. Can you state your name, Mr. Johnson?
Yep, Levi Johnson.
Joe Hall, followed by Joseph.
All I can say, Your Honor, and you were witness to it, I had 3 serious orthopedic surgeries and I always came to court.
I know. You did. You did.
Crutches, wheelchair, I was here.
You're just a better person than you. Did I say that? Oh, yeah, sorry. My bad. All right.
Anyway.
What are we doing?
Ms. Hughes and I are speaking. She's providing me additional information. We're asking to adjourn, jointly asking to adjourn the PCC, but Ms. Hughes, what do you think?
I did at least 2 weeks.
2 weeks ago? Okay. Probable cause conference, April 25th, 2024, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
All right, thank you. Calls the case of the People versus Hoa Yin.
Senior Assistant Prosecutor on behalf of the people.
Your Honor, Joe Simon on behalf of Mr. Wen. State your name for the record.
Wen.
Okay.
And you're, oh,
I put my term somewhere.
thank you.
Unless you want to hear me say it again.
It's funny you didn't say yes.
You gave from the script.
I know.
Being polite is, yes, a bit of a
Not
script for
something
me.
in your personality.
No, it is a bit of script for me. Anyway.
To follow a script to be polite.
Yes.
Yeah. Anyway, I'm dizzy. My understanding is another joint request to adjourn the PCC to April 25th.
Probable cause conference, April 25th, 2024, 9 a.m. or as your invite indicates, bond continue.
Thank you.
Thank you. Court does call the case People State of Michigan versus Renee Scholl.
Senior Assistant Prosecuting Attorney for the people.
Please.
Matthew Answer, Assistant Public Defender, with and on behalf of Ms. Scholl, who appears via Zoom.
So you don't know where she is?
If she's not on Zoom, Your Honor, then I will call her right away. I'll make sure she gets on. I know I sent her the link. I know she knows what time it is.
She's not here. Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety. That warrant will issue immediately. Thanks. So when you call her, you can tell her that. Court calls the case People versus Lawrence Turner.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Turner, who should also be present by Zoom.
He is. Could you unmute and state your name?
Lawrence Turner.
Thank you. All right, what are we doing?
All right, that's for an adjournment of the probable cause conference. We had adjourned to the state for a restitution number. That number has been provided, but there is no supporting documents at this time. So Ms. Barroso is going to look into that.
Probable cause conference, May 2nd, 2024, 9 a.m. or as your invite indicates, bond continue.
Thank you, Your Honor.
Court calls the case People versus Jeremy Anderson.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Anderson. Mr. Anderson, can you please state your name?
Jeremy Anderson, sir. Thank you.
We're asking for an adjournment to obtain some discovery, Your Honor.
April 25th, 2024.
Thank you, Your Honor.
9 a.m. bond continue. Court calls case People versus Jonathan Collins.
Sam Bernstein with and on behalf of Mr. Cologne, actually.
Cologne.
Jonathan Cologne.
Your Honor, asking for an adjournment to work on a resolution.
Probable cause conference, April 25th, 2024. And the your invite indicates bond will continue.
Thank you, Your Honor.